you have a right. You absolutely had a right to object to media coverage. You did it in the correct way. We've addressed it in a civil way. The court is dedicated to making sure that any hearings that I hold that are required to be public are public, unless there is a good reason that they shouldn't be.
Good morning.
Let's go ahead and go on. We're on the record on the matter regarding who I believe is present as is I believe on there too. Yep. Okay, parties are present. Let's go ahead and get the other appearances.
Good morning, Candice Saip, bar number 14166 with the District Attorney's Office.
Loni, Pollard, Permanency Specialist, Department of Family Services.
Lyttle, 11640, Cap Attorney for
grandparents of
Your Honor, Lewis Schneider, bar number 9683, on behalf of Your Honor, who's present by Blue Jeans as I am.
Good morning, Your Honor. David Jacks, bar number 12409, who is also present via Blue Jeans.
Okay. Also present is a screen name for our Nevada judges, and their cameras are in the courtroom pursuant to a previous order that allowed them to be present. The court, before we get into the heart of the hearing that this is set for, which is a hearing to rebut presumptions under NRS 432B.555, yesterday, I believe there was an objection filed by the on behalf of by their counsel regarding the presence of the video camera in the courtroom during these proceedings. That was done just yesterday. As I'm looking at the rule, you know, the media request is supposed to be done 24 hours ahead of the hearing. The media request that was completed in this one did allow for continued media coverage in other hearings as we were past any of the hearings that were specifically ruled by NRS 432B to be not public. And so, you know, objecting at this point, I think, on a hearing by hearing basis is probably appropriate. There is a written objection. I have reviewed it. If the attorneys would like to be heard on that first, before we get into any details of the 555 hearing, I'm happy to do that. Is that what you'd like to do?
Judge, I know you know the drill. I'll just submit to the court on this.
Okay, that's fine. I've reviewed the objection, and based on my review of it, there's a few things. The objection appears to rely to some degree on 432B 280 and 290, which are the directives regarding how information reports and different things are compiled and kept confidential. I'd note that in 432B 280 subsection F, the court specifically excluded as an entity that the department is allowed to release information to. I'd also point out that 280 and 290 govern the department, the agency that provides child welfare services, their activities, not the court. The court isn't an agency under the definition of those statutes, and the court is allowed to hold its proceedings. Under 432B.430, these proceedings are presumed open to the public except with specific exclusions, and a 555 hearing is not enumerated in that. The objection does, though, also rely on a Supreme Court rule regarding video coverage of proceedings. If the video camera were not in the courtroom, it would not have any relevance or bearing on the argument in hand anyway. An already authorized media source being able to view these proceedings that are by rule open to the public, they're allowed to do it. The question is, are they allowed to have a video camera in under the court rules, which require the court to consider a number of things, including impact of coverage on the right of any party to a fair trial, which I think is probably the most relevant here based on the arguments that were made as the parent's criminal trial is still pending, has not happened yet. And that's really kind of where I think we get into the complications here. The impact of the coverage on the right of privacy of any party or witness, the impact of the coverage upon safety and well-being of any party, witness, or juror, the likelihood that coverage would distract participants or would detract from the dignity of the proceedings, which I've already made a particularized finding on, and I found it wouldn't. The adequacy of the physical facilities of the court coverage, which I also have made a finding on, and any other factor affecting fair admission of justice. So, administration of justice. I think the main thing that was highlighted as well in 432B 430 in the objection was the child's wishes being taken into account, which the child's attorney, Mr. Lyttle, can speak to. They're allowed to tell me what the child's legal wishes are. But the only restriction on me keeping 432B proceedings, other than those that are enumerated that are not to be open to the public, is the child's best interest. And considering the child's wish as part of making that analysis or making that determination, I had previously made a determination that the child's best interest would not be negatively impacted because I secured a promise from our Nevada judges that the child's name and images identifying features for the child particularly would not be utilized. I know there was some discussion of parties. Frankly, they have an ongoing very public criminal proceeding where their names are a matter of public record. The fact that there's a dependency case that might be in some way related, I don't know that really affects their privacy and other things too much. I am concerned, though, about their right to a fair trial, and so I want to speak to that. NRS 432B.555 legally, on its face, only applies when there's actually been a conviction, which does not apply in this case. There has not been a conviction. It's usually a post-conviction hearing, and because it's a post-conviction hearing, the party's right to privacy is completely out the door. There's not a whole lot to really worry about at that point because legally all those facts have been established in a public forum. And so their Fifth Amendment right would not apply and a number of other things. But in this case, there was a stipulation that the presumption would apply with respect to the child that I have under my jurisdiction, which I will note is the party's child that they have in common, not the other two children that were originally part of the proceeding. This child has not been alleged at any point that I know of to be the direct alleged victim of any of the allegations that may be going forward in the criminal proceeding. But at the same time, because NRS 432B 555 requires me to make findings by clear and convincing evidence that this child would not be exposed to mental or physical harm by being placed back into the parent's care. It has, from time to time, these hearings have required the testimony of the parties in order to clarify some things for the court and for the court to reach a comfort level with releasing the child to the family. And that's where the problem arises here is if the court were to feel that the parties could not overcome this burden without their own personal testimony, then absolutely their Fifth Amendment rights would, in my mind, be paramount, even though they have secured a promise and an agreement with the department and the state that things said in these proceedings would not be used in criminal proceedings against them. That does not change the fact that some of that testimony could make its way into the public forum through the media coverage that we have in place. So in considering that, I think that I could adequately protect their right to have a fair trial in their criminal proceedings by directing that the portions of these proceedings that call for direct testimony from those parties could not be recorded or videoed. And I think I could protect their agreements with the state and their Fifth Amendment rights in that situation. And frankly, I could order that none of their responses, even if they weren't recorded or videoed, be relayed in any media coverage, because I think that also could potentially taint the jury pool. But at the same time, as I've reviewed this case and the reports that I've already received from the department, I don't know that these parties' testimony is really needed to overcome the presumption in this case. As I said, the child in question was not, to my knowledge, a direct alleged victim of any of the acts that were alleged in and are still unresolved and unadjudicated in the criminal proceedings. Those impacted other children that were not these parties' child in common. The fact that this child's age and that this child has the only two common parents to this child are the parties we're talking about. And then based on the updates I've received from the department regarding their compliance with case planning, their understanding of the issues, their completion of certain services, the way that their contact with the child has been going through visitation, the information I've heard from the placement as to the appropriateness of the parents. To be frank with you, given those reports that are already part of the record and are part of the state's presentation to the court, I think these parties can rebut that presumption without their own personal testimony, which I think would then again adequately protect them from a Fifth Amendment problem, because this is not your normal 555 situation where it was created by agreement rather than the language of the statute, and the fact of a conviction. I think that unless there was any opposition by the state or anybody else that's an interested party, the court could make a decision based on information that's already placed into the record if everybody's just willing to submit and have me take a look at it and see if they can rebut the presumption. Because absent the state raising an objection that they couldn't, and I haven't seen that anywhere in anything I've seen so far, I believe they can, based on the basis for these hearings. So I know that's kind of a long way of getting to everything that we're talking about, but I think that the merit of the objection probably most applies to their right to have a fair criminal trial in front of a jury and not having the potential jury pool tainted by anything that might be reported in the public by means of the video coverage of this hearing. So knowing where the court's at on these different things, did anybody want to address the court on any of those specifics? Mr. Lyttle will certainly be free to let me know what he believes the child's legal wish would be so that I can incorporate that into my best interest analysis. But with respect to the other particular findings that are required, really the only one that is holding any real sway with me right now is the impact that this coverage might have on a party to a fair trial, meaning their pending criminal trial that still has not been resolved. With respect to rights to privacy and things like that, I think I've already adequately covered that for the child. I don't know that the parents' names being out there in the public is having a dependency hearing when it's a matter of public record that they have a criminal trial where there's been an allegation of child abuse and neglect on a child. I don't know that really further diminishes the right to privacy, their safety, or anything along that line. So you guys can take it away however you want to go in whatever order, but I'm happy to address any of your concerns, or if we are good to go, just get to the heart of the matter and whether or not this particular child can safely return to the parents' care in spite of the stipulated 555 presumption.
Your Honor, I'd like to hear what Attorney Lyttle has to say, and then I'm prepared to go forward.
Okay.
Your Honor, I think that we can all agree this child is obviously too young to express wishes that I think would be relevant. And so I think we just have to fall back on the best interest analysis. And I think the court has already done a good job of outlining what my concerns would be there and has already come up with, some safeguards that address those concerns. So I'm not going to add by way of any additional objection.
Okay. Does the state, did the state plan in any way to oppose the rebuttal of the 555 presumption today, or does the state feel that enough information has been presented to the court by way of the most recent permanency report and any updates that have happened since then with respect to the parents' ability to overcome that presumption?
The state was not going to oppose the 555. It's an uncontested hearing, and I have no objection to relying on the reports already part of the record.
Okay. So hearing all of that, Mr. Schneider, I don't see a need for your parties, potentially yours and Mr. Jackson's parties, to even potentially testify today. So I don't know that I need to make any orders specifically towards our Nevada judges other than all those that are already in place. Child's name, image not be used. in the proceedings and any direct statements made by the parents in the course of my proceedings that may have a Fifth Amendment bearing on the criminal trial not be used in media coverage. Or did you want to go forward with either a submission, or did you want to add anything to the record on top of anything that's already been submitted to the court by way of permanency updates?
No, Your Honor, I'm entirely satisfied. In fact, after reviewing the file and hearing from the state, and Judge, I think the court should know that it's been a real pleasure working with the state on this case. It's not often that I get a deputy DA that's informed and so kind and professional. So having said all of that, Judge, we're prepared to submit to the court on this matter.
Okay, Mr. Jacks, how about you on behalf of your client?
Your Honor, I'll submit as well.
Okay. All right. I have previously, in the course of my permanency hearing, made some statements on the record regarding the updates from Red Rock Psychological Health, from the placement regarding the parents' appropriateness, also from the underlying allegations and how they directly bear on this child. Based on the submission of the documents that we already have in the record, the court is comfortable that the parties can, by clear and convincing evidence, rebut the presumption that this specific child that we are talking about today, and it'll make it easier for your editing purposes, I don't even need to use her name right now, that it would not subject her to emotional or physical harm to be returned to the parent's care. That I will say with the caveat, we do not know what the outcome of your criminal case will be, so I would encourage the parents, based on my allowing them to have the child placed back with them, to make sure that you already have legal arrangements in place in the event that any kind of custodial decision or anything made in that case would deprive you of being able to immediately see to this vulnerable child's needs. Okay? That is, you can talk to your attorneys about advice as to how to do that. I can tell you by way of information that's typically handled with guardianships and different things like that, or provisions in place so that this child's not disrupted in any way. The court would also be happy to put on the record that the current placement have shown themselves to be protective and effective caregivers for the child, and would probably be a good candidate to be involved in any of that planning. You know, as far as that goes, I do still have a permanency hearing, a review hearing on schedule for November 17th. I'm happy to hear what the department's position is with respect to continued jurisdiction from this court at that time. But I'm going to go ahead and authorize reunification efforts between this child and the parents based on a rebuttal of the 555 presumption. Mr. Schneider, Mr. Jacks, if you want to put together a joint order citing to those specific best interest factors and factors regarding the child's safety that are enumerated in the most recent permanency planning hearing report, that would be fine. Run it by the state for sign off and Mr. Lyttle for sign off, and I would be happy to sign off on that one. This court is one of a limited jurisdiction, and I think that its purposes are being served and have been served to date for the safety of this specific child. I'd also like to say that the parties have conducted themselves in a professional way. You absolutely had a right to object to media coverage. You did it in the correct way. We've addressed it in a civil way. The court is dedicated to making sure that any hearings that I hold that are required to be public are public, unless there is a good reason that they shouldn't be. And I think we all have had plenty of practice with that at this point, knowing what the rules are that bear on that. And so I thank Mr. Schneider, Mr. Jacks for their submission to the court, and the way that it was laid out gave the court plenty to digest and address today on the record. So that being the case, I don't think there's anything else we need to get on the record today, is there?
Not at this time, Your Honor, from us.
Okay, thanks everyone for your participation then. And the objection was noted, but for purposes of this hearing, it appears to be moot. So we will go forward. The next hearing in this matter is November 17th at 2 p.m.
Thank you, Your Honor.
Thank you.
Thank you, Ms. Sapp.
Thank you. You're welcome.
Thank you, Your Honor.
Thank you.
Buddy.